Welcome to our IP Insights on the question, how will the UPC decide cases under the doctrine of equivalence? For the time being, the UPC has not yet issued a single decision in which the claimant had asserted claims under the doctrine of equivalence. But no crystal ball is needed. The next case will soon come. Julia, is there any clarity how the UPC will decide such cases?
Tobias, definitely not. Neither the agreement on a unified patent court nor the rules of procedure provides for a clear legal framework as to how the UPC shall adjudicate such cases.
This is true. And the same holds true for the case law of the member states of the UPC. Different national DOE approaches exist that are sometimes even applied in parallel by the national courts. However, there are also many commonalities in the national approaches.
Yes, and these commonalities suggest that three factors will play a decisive role in the soon-to-be-rendered DOE case law of the UPC, which could ultimately lead to a three-step DOE test being applied by the UPC. The first factor is the technical equivalence of the variant. The second is the obviousness of the variant, starting from the technical teaching of the patent. And the third factor is the legal equivalence of the variant.
Yes, that makes sense. German courts apply a similar three-step test, and the Dutch courts do too. Also, the UK has approximated its case law to such a three-step test, which tries to strike a fair balance between legal certainty for third parties and a fair reward for the patentee.
However, French and Belgian courts use the function-where-result test known from the US, and Italian courts apply various DOE approaches in parallel. So there is still some inconsistency.
Yes, indeed. But the UPC will align these inconsistencies. Also, the Pemetrexed decisions of the member states of the UPC has led to a great deal of harmonization, in particular with a view to the relevance of the file wrapper for the DOE.
Claim amendments made during prosecution in response to novelty or obviousness objection qualify as a waiver of the scope of protection, whereas claim amendments which are made to overcome formality objections are irrelevant.
Finally, most UPC member states rightly accept the concepts of the Formstein and the Gillette defenses, since there is simply no valid reason to extend the scope of protection into the ambit of the prior art.
Thank you, Tobias. If you want to learn more about the UPC, visit the UPC Special on our website and our newly launched UPC blog. You can find the link in the description of this video. Thank you very much for your attention.